Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, are you ready for some football? Antitrust and the NFL. The National Football League has been the subject of more antitrust litigation than almost any other industry. In this episode of Our Curious Amalgam, we'll explore why and what we can learn from this body of cases. Joining me today is my co-host, Sergei Zaslavsky. Hey, Sergei.
Hi, Christina.
So what are we doing today?
Well, we're talking about football. I love football. I love antitrust. I figured it would be a lot of fun to do an episode that covers both. There's been a lot of antitrust litigation in football, as you mentioned, and I wanted to have a conversation that would give our listeners a glimpse into this body of law and also try to take a look at what makes these cases important or interesting for the broader antitrust body of law.
Great. And who's the other football fanatic joining us today?
Well, today we welcome Professor Steve Ross to the program. He's a professor at Penn State Law. He's the executive director of the Penn State Center for the Study of Sports and Society. And he has been teaching, researching, and writing about sports and antitrust for decades. Welcome to the program, Professor.
It's a pleasure to be here. I'll also note I was the founding editor-in-chief of the Antitrust magazine, so I'm happy to continue the new high-tech way that the ABA section does outreach on interesting issues about antitrust.
Yeah, an ABA veteran as well. Well, we're very lucky to have you. So to get started, I was wondering if you could give our listeners just a description of what football litigation tends to be about. Like my colleague Emily Murphy actually did some research into this, and she found that there were 50 published antitrust opinions having to do with professional football. What's at stake in these cases? What are the issues that tend to come up?
Antitrust litigation tends to focus into four major categories. They almost all involve the fact that the National Football League, like most North American sports leagues, is a joint venture among the owners of the clubs in the National Football League. So most NFL policies, as I'll discuss in a minute, are agreements. When there is an agreement on how you will compete for labor, it can be subject to extensive antitrust litigation, which we have seen. In addition, each club owns a variety of intellectual property rights to broadcasting and sponsorship. Many of these rights are then assigned to the league and then sold collectively by the league. That also in turn results in a significant litigation. Because the National Football League is so popular, there are more people who would like to own a franchise than there are franchises. And so the conditions of entry into the league can become the source of litigation. And then finally, owners may wish to move their clubs to another location. Sometimes the league wants to let them do it. Sometimes the league doesn't want to let them do it. And that issue also gives rise to extensive litigation. So those are the four major categories of antitrust litigation.
Interesting. So we got just general league policies. We have relocation. We have new franchises, and we have IP rights, 4 buckets. Maybe give us a couple of words about this first bucket, league policies. What kind of policies have been subject to lawsuits?
The first category is league policies primarily concerning labor. So sports leagues since 1876 with baseball, actually since 1889, with baseball, have a variety of agreements among themselves on how to compete for players of the sort that, say, law firms could never get away with doing. And these are therefore often subject to antitrust litigation by players who would like to receive more open competition for their services. So that is a huge aspect of antitrust litigation.
Interesting. Maybe give us a little bit more details about the second category, IP rights. What kind of things do we see being litigated in that bucket?
So they can fall. They're really all over the lot. You have the collective sale of rights, which may limit the ability of people to watch games that they would otherwise like to watch. You might have the collective sale of sponsorship rights that would limit the ability of individual clubs to get more lucrative sponsorships. And antitrust also affects just the ordinary way they do their licensing. So that would be in that category as well.
And maybe give us a few words about the third and fourth buckets, new franchises and franchises trying to move from one city to another. What kind of things have been the subject of lawsuits there?
So listeners who may be familiar with global soccer see a unique problem in the United States that doesn't happen everywhere else. Everywhere else in the world, who plays in the top league in the country is determined by merit. Anybody can join a league and you work your way up from the 10th tier to the top tier. In the U.S., you can only join a league if the other members of the club let you in. And you can only move your team if the other members of the club let you move. So if you want to have a new team, there are only two ways to do it: is to find an existing owner to get them to move to your city, or to persuade all the owners that they should expand and allow a club in your city, as opposed to the rest of the world where you would just start a club and then move up the hierarchy.
That's interesting. So let me ask you if there is any particular case that comes to mind as being particularly important for broader antitrust doctrine, any football case that non-football fans should care about.
The fundamental case to understand sports antitrust is actually one of the more recent ones, the National Football League against American Needle. It involved a collective decision by the 32 owners to assign a variety of their intellectual property rights to an entity called NFL Properties that they themselves ran. And then NFL Properties proceeded to make a number of decisions about the joint licensing of the intellectual property that the NFL clubs had. This was challenged under the antitrust laws, and the lower courts found that Section 1 didn't apply at all because the National Football League was a so-called single entity, akin to a corporation. The Supreme Court unanimously rejected that. They found that it was not akin to a corporation. It was a joint venture. And the key focus, which I think is relevant both for sports and non-sports, is that decisions are made by the 32 owners who are interested in the overall welfare of the league, but they are also interested in the specific welfare of their club. And that made it more akin to a joint venture among competitors subject to Section 1 than a single corporation. The example I use is that when the General Motors Corporation, which is a single entity, makes decisions, it's done by a board of directors that are solely interested in the overall welfare of the General Motors Corporation. If General Motors were like a sports league, the major decisions of General Motors would be made by the president of the Chevy division and the president of the Cadillac division and the president of the Buick division. But that's not how it works in more traditional corporations. So that case is a really important case to understand, both generally for the differences between joint ventures and single entity corporations, but also to appreciate that the National Football League is a they, not an it. And decisions by the National Football League are made by the collective judgment of the owners about what is in the interests of the Washington football team or the New York Giants or the New England Patriots, not the way a board of directors would based on what is in the interest of the overall National Football League.
Yeah, that's certainly a case that I know comes up a lot in my practice. I think many practitioners who are not football fans certainly have run into that case a lot on intra-enterprise agreements. Besides that specific case, is there something more general about this body of law, NFL cases, that provides important lessons to antitrust practitioners in your view?
Yeah, I would cite two other cases I think that have a lot of value. One is the 1984 NCAA against Board of Regents of the University of Oklahoma case. This involved restrictions on broadcasting football games. Your older listeners will remember prior to 1984, there were about 4 or 5 college football games on television every Saturday. Now there's about 50. And it was because of this NCAA rule. The significance is that the court clearly articulates a rule of reason approach and really makes it clear that what lower courts have fully articulated as a 3-step process where the court identifies whether there is market power and therefore whether antitrust needs to be concerned at all about the restriction on trade, because it really does restrain trade. Secondly, it looks to see if there is market power, whether the defendants have any legitimate justifications that are pro-competitive for their behavior. And then finally, whether the restriction is more than is reasonably necessary to achieve those legitimate objectives. In that case, the court found that college football was distinct from other products. It found that the NCAA did have some legitimate justifications for its rulemaking, but none of them were remotely tailored to the restriction on broadcast rights. The restriction on broadcast rights was primarily designed to protect some key teams in competition with other teams, and the court found that is not a legitimate justification. So I think that sets forth a process that anybody who ever has a rule of reason case needs to take a look at. And the other case that I think is instructive, more for the entire picture of the case as opposed to any specific holding, is a case involving the NBA, National Basketball Association, and the Chicago Bulls. It obviously plays a key role in NFL litigation as well. And the significance of the case was this was a restriction on Michael Jordan and the Bulls having their games on superstations all across the country where they were competing with local broadcasts. And the court goes back and forth on the rule of reason and initially strikes down the restriction and then remands. And then the case got settled about 6 years later. To me, one of the most significant things about the case is that the initial claim that the NBA set forth was plausible, that the Bulls' activity that was being prohibited would interfere with their legitimate interest in selling TV rights in other places. The problem is, after antitrust discovery, it was revealed that these fears were completely overstated. And this is a very common problem in joint ventures and antitrust. If you have a joint venture that has market power, individual members want to reserve the right to prevent the venture from doing something that will harm their own firm's individual interest. The problem, and we know this extensively from studies of behavioral economics, is people tend to overstate the possible harm of an innovation to their own interest. And as a result, what will often happen is that a innovation, which is actually not that harmful, might get vetoed. And I think that's a particular concern for litigators to recognize that you've got to back up with facts your proposed claim It's also incredibly important for antitrust counselors when sitting down with their clients to work through to what extent their fears are actually legitimate and based on reality.
Well, that's certainly some good advice. Certainly, rule of reason is something that most litigators grapple with, or most antitrust litigators, I should say, grapple with quite frequently. And those cases do tend to be very fascinating because they tend to be fact specific, and there do tend to be both arguments on both sides. You have potentially some restraint, but also some potentially good justification. And you really have to dig into the facts to figure out if the justification makes sense and outweighs the effect of the restraints. I'm curious if in the cases you mentioned that the court found that the justifications that were proffered did not pass muster. What are some of the justifications that have succeeded in football or sports cases more generally? And is there any lesson to be drawn or line to be drawn between justifications that tend to be accepted by the courts in these cases and justifications that are rejected?
So sports is a pretty specialized industry, and there's a number of justifications in sport that really would not work in almost any other industry. I think as a general lesson, the court has made clear that the justifications have to focus on a benefit to consumers. To use the words from broadcast from the Board of Regents case, is the justification going to make the price lower or the quality or quantity higher? Or is the justification going to render output more responsive to consumer preference? And a justification that might be socially worthy is not a legitimate justification because lots of people think so. A good example of that is in the area of was the recent NCAA against Alston case, where the district, it wasn't even an issue before the Supreme Court. The district court early on correctly said that a worthy desire to take profits from football and basketball and use it to provide hundreds of student athletes with intercollegiate athletic opportunities in all the other sports was not a legitimate justification to restrain trade in football and basketball. You could go to Congress for an exemption, but you're not allowed to do that yourself. So the focus needs to be on consumers. Let me use the specific example that the National Football League has used, and I think it can be misleading to people in other sports. The National Football League has successfully persuaded courts that competitive balance among the 32 teams in the National Football League is a legitimate justification because it makes the overall popularity of the National Football League greater. And I think the idea of parity in the National Football League has been successful. What people don't realize is the National Football League is an extraordinary league. They only play 8 home games, and the vast majority of people who consume the National Football League watch it on TV and typically do not only watch teams that they are avid fans of. In almost every other sport, that is not the case. The National Football League set a record when the Green Bay Packers and then Pittsburgh Steelers played in the Super Bowl. There is no other league in the world where the championship being played by the smallest market in the league and the highest and the third smallest market in the league would set records. So the National Football League has a compelling argument for competitive balance. It is simply not true that Major League Baseball would be better off if the New York Yankees and the Pittsburgh Pirates were equal over a 10-year period. So when you have a justification like competitive balance, you still need to tie it into a proof that consumers actually want the level of competitive balance that you're trying to achieve.
Well, it makes sense. And I think the lesson, as always, is in the antitrust, there are some generalities you can apply from industry to industry, but so much is fact specific that perhaps even an argument that applies to one league may not apply to another league, even if they're both professional sports leagues. So first lesson is know your industry, know your market to make your arguments effective. You talked a little also about JV structure, the joint venture structure, and how that was a very relevant aspect of the American Needle decision. And I think you mentioned that some leagues outside of the United States work differently than U.S. leagues. Are there different types of possible joint venture structures that other leagues across the world may adopt that would lead to have antitrust implications?
Sure. There was an effort to do this very thing in the United States with Major League Soccer, but it didn't work. The initial plan for Major League Soccer was to structure it as a genuine single entity where it was run by a board of directors and shareholders, but they couldn't get people to invest unless they could own a club. And then they couldn't get people to invest in a club unless they could share in the collective management, which made Major League Soccer more typically a joint venture. There is an American example in sport, and that is NASCAR. NASCAR is run by a private company, largely owned by a single family, the family of Bill France, who founded the sport, and it is a true single entity. It sets the rules, and if you want to be a racetrack to host NASCAR, you need to go to a single entity. If you're a racing team and you want to participate, you do it under their rules. And when NASCAR has to try, it consults, but it just does it. It doesn't require a 2/3 vote of the drivers or a 2/3 vote of the racetracks to achieve its goal. There are a number of leagues around the world that have become structured in a similar way, where you have a corporate board of directors and then you have a franchise agreement. I wrote a law review article about it where I characterized it as the difference between American sports, which look like the United Nations, and some of these other sports leagues, which look more like McDonald's. And I think that's a good way of thinking about how you can structure a league if you were so inclined to do so. And that would significantly minimize antitrust risks for the league.
That's interesting. I have not studied the subject of whether there's been much NASCAR antitrust litigation, but I guess I wouldn't be surprised if there was much less NASCAR antitrust litigation than there is for other American sports leagues.
Right. Now, they are still subject to Section 2 claims, but again, this and some Section 1 claims, which rarely succeed if you can show that NASCAR was unlawfully conspiring with one competitor to put out of business some other competitor. But otherwise, there's really far less than we see in the National Football League, certainly.
Well, Steve, a very interesting topic and something that will look for additional doctrine and litigation in the years to come. But before we let you go, we do always ask all of our guests a couple of questions, more fun questions. The first is to tell us something interesting about yourself that most who work with you would not know.
I think a lot of people who know me know what an avid sports fan I am, with actively following teams in multiple sports all around the world. But I was paired with somebody who was one of the least interested lawyers about sports in modern times, Justice Ruth Bader Ginsburg. I was a law clerk for her. She had no interest in sports, but I did have a humorous interchange with her once when she bemoaned the fact that the Brooklyn Dodgers had left Brooklyn to go to Los Angeles as part of a franchise relocation that potentially has antitrust implications. And she said, "I've never forgiven the Dodgers." And I pointed out that she also had left Brooklyn, to which she got a good chuckle out of that. So,
yes, that's great. Nothing better than a good RBG story. And Steve, advice that you have for young, I guess I should say law school students or even professionals who are interested in doing what you do?
Well, the thing about sports to recognize is that there are more men who play in the 4 male major leagues in sport than there are attorneys who are men and women who spend most of their time practicing sports law. So it's a very difficult area to get into. And the best way to get into it, if you don't have some family connection, is actually to learn genuine skills that sports leagues need in a non-sports context. Perhaps the most lucrative sports practitioner currently is Jeffrey Kessler from Winston-Strawn. And he got into sports because he was a seriously good antitrust litigator, litigating a number of important cases that had absolutely nothing to do with sports before he developed his expertise in representing players and others in his practice. It's not as fun as going into sport, but as I tell students, it's like the elite athletes spend a lot of time in the weight room and a lot of time working on drills that are not as fun as playing sports, and they do it to become skilled at what they do. And if young lawyers want to get into a highly competitive area, they really need to work on core skills.
I think that's great advice, Steve, and certainly consistent with colleagues and peers of mine who wanted to go into sports law. It does seem like a very difficult space to break into. And now we're going to move to the final segment of our episode called The Curious Hat.
And now it's time for The Curious Hat.
So Steve, could I ask you to pick a number 1 through 10?
7.
7. Tell us about a teacher who had a major influence on you.
I went to Berkeley for law school, and I had a Professor Jesse Choper for both constitutional law and corporate law. And he showed me how to teach. He emphasized how fun it was to be a law professor, and how one is a rigorous scholar that separates law from your personal preferences. And he has really been along with Justice Ginsburg, my principal professional mentors. And he really, his influence led me to become a professor as opposed to doing something else in a law career.
Sounds like a wonderful mentor. It sounds like you've had a number of great mentors during your career. Yet another piece of advice for all of our listeners. So Steve, thank you again for joining us today. And to our listeners, thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.